Now, where co-owners of a free co-ownership relationship feel that they can no longer continue with their standing co-ownership relationship or agreement, they can terminate their co-ownership relationship or adjust the co-ownership relationship. In this regard, termination refers to the co-ownership relationship coming to an end, so dissolution of the co-ownership, while readjustment refers to where the co-ownership continues, but what is achieved is the adjustment of the undivided co-ownership shares of the co-owners. So after this termination or adjustment order has been made, the co-owners will then have different percentages of undivided co-ownership shares as they had before the action for adjustment was instituted and the order was made for adjustment. Now, termination or adjustment can be obtained by way of the common law action of the actio communis dividendo, also known as the partition action. This is a common law remedy that provides the means to terminate or adjust the co-ownership relationship. As I've said, it's also known as the partition action, so partition action. Now, an agreement that the free co-ownership may never come to an end cannot exclude or waive the actio communio from being available to co-owners. In other words, it will be an invalid agreement as co-owners have the inherent right to terminate their co-ownership, and this right cannot be excluded or waived by way of agreement. Please see the case of Municipal Employees Pension Fund and others versus Crucial Investments. It's a 2022 case. It's not prescribed, but there it's really emphasized or highlighted this idea that free co-owners have the right to terminate or adjust their co-ownership relationship, and that they cannot contract out of it. Now, in this regard, co-owners may, however, agree that the property may not be divided or that the co-ownership may not be terminated for a reasonable time, for instance, a year or so. But this is not possible. A clause like this cannot completely waive this right. So it's fine if the co-owners agree that the parties are not allowed to terminate the co-ownership, for instance, for the first 6 months of the agreement or the relationship. But an absolute exclusion of termination is not valid. Now, the result of the partition action can be described as being threefold. First of all, it will consist of an order for the property to be sold or divided if dissolution, in other words, termination, is requested by the co-owners. It also then includes the drawing up of a final account of expenses and losses, and this expenses and losses obviously will have to be addressed before the termination or dissolution of the co-ownership can be made final or can come into effect. And then an order for the dissolution, in other words, termination of the co-ownership relationship, or order for the adjustment of shares depending on what the co-owners asked for in terms of the actio communis dividendo. Now, before unpacking these three aspects of the actio communis dividendo, let me first take you through an overview of the process and steps that accompanies a partition action, in other words, that accompanies the actio communis dividendo. Now, before the parties approach the court with the actio communis dividendo, the parties must first attempt to come to an agreement as to how they want to terminate the co-ownership or as to how they want to adjust the co-ownership shares. This obviously depends on what they want. Do they want to terminate or do they want to adjust? This is because the actio communis dividendo is only available where the co-owners first try to settle outside of court and to exhaust all dispute resolution mechanisms. Attorneys drafting co-ownership agreements ordinarily encourage co-owners to include dispute resolution clauses in their agreements and to insert clauses to regulate termination and adjustment of the co-ownership relationship. Now, usually when these clauses are not included in the co-ownership agreement, co-owners struggle to find solutions that they are all happy with and would then approach the court for assistance. So they would then institute the actio. However, in instances, there can also be instances where such clauses are included, but the clauses simply fail to solve the disputes between the parties, and in that situation, then the co-owners will be able to approach the court with the partition action, so the actio. Now, only once the co-owners have failed to agree outside of court as to how to terminate or readjust the co-ownership relationship can they institute proceedings in terms of the actio. Now, when the actio commune dividendo is instituted, the court must be approached with a proposal as to how the termination should take place and how the property should be disposed of. Or, in the case of readjustment of the co-ownership relationship, the parties must provide the court with a proposal that shows how the adjustment to the undivided shares should look like. Now, if not approached with a proposal, the court may delay proceedings by sending parties back to come up with proposals on whether the co-ownership should terminate or should be adjusted or readjusted, and how this should be achieved. In the event that there is a proposal, the proposal must consider how the termination will look or how adjustment will look, as already indicated. So must the property be divided proportionally between the co-owners, if divisible, or must it be sold at an auction, or will one of the co-owners purchase the interest of the other co-owners? If readjustment is desired, they will need to indicate how the new proportions or shares must look. In other words, if they want to terminate, they must set out whether one of the co-owners will purchase the undivided shares of all the other co-owners to become the individual owner of the property, or whether they have identified a third party that they will be selling the property to, or whether they are going to sell the property at an auction and the process that will be followed in this regard. Now, if, however, the court's assessment of the proposals indicate that what is proposed will not be just and equitable, which would ordinarily be the case where the parties are not in agreement regarding the proposal or the way forward, the court has a wide discretion to make an order that will be just and equitable. In other words, under the court's wide discretion to make a just and equitable order, the court will first evaluate or review the fairness of the proposals. If the court is satisfied based on the facts and the proposal that the proposal is just and equitable, the court may accept the proposal. The court will then make an order based on the proposal. So in other words, the order would either be for sale or division depending on which proposal was actually brought to court and which proposal the court found is actually just and equitable. If the court finds that it is not fair, in other words, not just and equitable, the court can reject the proposal in terms of its wide discretion. Now, when the court rejects the proposal, its just and equitable discretion extends then to deciding what a fair order would be in the circumstances. So the court can then decide what the best way forward should look like. We have seen now how a petition action would look like or play out in a court in terms of the process and steps specifically. And we noted that ultimately the court decides on how the dissolution or readjustment should look based on what would be just and equitable given the proposals on the table and then also given the circumstances of the case. Now, as mentioned in the previous slide, the court must consider termination or adjustment depending on what it is that the co-owners want. If the co-owners want to terminate the co-ownership but cannot agree on how this should happen, in other words, what should happen to the property, should the property be sold and through that then the co-ownership should be terminated, or should the property be divided and then through that division the property should be, the co-ownership should terminate. The court will then exercise its just and equitable discretion to decide the way forward when the parties cannot agree as to what should happen with a property. Now, if division is proposed or considered by the court the court will determine whether division of the property is, first of all, possible, and secondly, equitable. Now, it doesn't have to be in that order, though. It will be equitable. So division will be equitable if the division, would be inequitable rather. So the division would be inequitable if the division would be prejudicial to the co-owners. And here the circumstances of the case should be instructive. The question of whether it is possible to divide depends on the divisibility of the property. In other words, division of the property amongst the co-owners requires that the property must be divisible. And to determine if the property is divisible, we'll have to apply the tests for divisibility. The question that is asked here, and I refer you back to week 1, where we looked at divisible versus indivisible things. The question here is, can the property be divided without the property losing its function, value, and nature? For example, if it will be uneconomical to divide the property will not be divisible. This is because the division will affect the value of the property negatively and therefore not survive the divisibility test, as value is one of the factors that we look at when we determine legal divisibility. Now, where the property has been made indivisible by law, the property will also be regarded as being indivisible. An example of this is Section 3 of the Subdivision of Agricultural Land Act that prohibits subdivision of agricultural land absent ministerial approval. Now the question then is, when does the SALA apply? So the Subdivision of Agricultural Land Act, SALA. The Act applies to land that qualifies or that's zoned as agricultural land and that can meet the definition set out in the Act for agricultural land. The aim of the Act is to protect the public interest, specifically to restrict the cutting up of agricultural land into uneconomical units. Now, Section 3 of the Act requires the Minister of Agriculture's consent before agricultural land can be subdivided. In this regard, where co-owned property is subdivided to terminate the co-ownership, the Minister's consent is required before the submission can be brought into effect. In this context, the 3 prescribed cases of Van der Bijl versus Low, Becker versus Duvenage, and Coetzee versus Coetzee are instructive and applies. Please read the cases and ensure that you work them into your notes here. Now, in a nutshell, in Van der Bijl, the court held that Section 3 of the SALA does not prohibit the court from finding that it would be just and equitable for agricultural land to be subdivided. However, Section 3 prohibits the registrar from carrying the order into effect without first obtaining consent from the minister. And this idea that the registrar won't be able to register the property or do the subdivision and then register it into the names of the new owners thereof, individual owners thereof, is also encapsulated in Section 6 of the SALA. Now, when you read the case and you read the facts, you will understand why the court came to this conclusion and why the court had to reiterate or explain that the court can still make a finding on the application of the actu communis dividendo for purposes of determining whether or not it would be just and equitable to order subdivision. And if you read the facts, you'll see that it's because Section 3 requires ministerial consent, and the conflict was really there about, or the dispute was really there about, if the minister must consent, the court actually doesn't have a role to play anymore. But read the case and see then what the court said about how the function of the minister and the court complements each other, and that there's still a place for both in this context. Okay, in Becker, the court added a qualification to the position laid down in Van der Bijl. The court in Becker confirmed Van der Bijl. However, where the court is made aware of the minister's rejection of the application for subdivision, meaning the co-owners approached the minister before approaching the court, and the minister refused to consent to the subdivision, the court is not allowed to ignore the minister's refusal to consent. the court will then not be able to make an order for subdivision. So Becker then added an important qualification to what was said in the Van der Bijl case. Please see what Coetzee versus Coetzee added to the scope of the just and equitable discretion the court has when it must contemplate the partition action in the context of land that is subject to SALA. You'll have to read the case and add those notes also to your class notes here. So we've now looked at division as a potential option in terms of the first part of court's order under the partition action, for purposes of the partition action. And we now turn to the sale as a potential option. Now, in the event that division of the property is not possible or equitable, the court can order that the property be sold to one of the co-owned parties and that the proceeds be divided proportionally among the co-owners who sold their respective shares. However, if it would be prejudicial to a co-owner at the time to order immediate sale of the property, the court may make an order for the sale to take place at a later stage. If it is, however, not possible to sell the property to one of the co-owners, the court may order that the property be sold at an auction to a stranger, or that a property be sold to a third person that has been identified by the co-owners. In this regard, the court will order for an independent valuation of the property to be obtained and for the co-owned property to be sold at a public auction. For an example of where the public auction was considered, you can look at the case of Krieger versus de Blanche. It's an older case. You should be able to find it on LexisNexis, and I think the full citation is available in your study guide. Now, this whole point of the valuator, an independent valuator being appointed, is to ensure that a fair value is obtained when the property is eventually sold. We now turn to the second part of the court's order in terms of the partition action, namely the drawing up of the final account. Now, when the order for division or sale is made, account is taken of all expenses and losses with regard to the property and is factored into the final division of the property if it is divisible, or division of sale proceeds according to the co-owner's undivided shares in the property, if the property is sold. The actio communis dividenda, or the partition action, is therefore not only an action for division and there through termination, but also to provide a final account of all expenses or improvements, losses, and then to set that off against the proceeds if the property was sold, or to take it into account when the property is divided between the parties. And this brings us to the final part of this, the third part of the court's order, which is the dissolution or adjustment order and its consequences. Remember, we said initially that there are really three things that an order in terms of the Partition Act can include. We now got to the third one, which really concerns the dissolution or adjustment and its consequences. If readjustment was found to be just and equitable, the court will then make a readjustment order. If it was possible, equitable, and practicable to divide, or if it was just and equitable to sell the property, dissolution or termination will take place through a division or sale order. Importantly, though, the order will not at that moment terminate the co-ownership or dissolve the co-ownership. Free co-ownership in the co-owned thing will only terminate once the property is transferred in the name of the new owner. So if the property is movable, this termination will take place the moment that the property has been delivered to the new owner. And where the property is immovable, the termination will only take place at registration.
The last question that we're going to look at in the context of co-ownership is whether acquisition of another co-owner's shares is possible. So in other words, if one co-owner can acquire the shares of the other co-owners, and in what way, or in what ways. So it is possible for co-owners to agree that one of the co-owners acquire another co-owner's undivided co-ownership shares. So it's possible that they can contract that this can happen, or that this should happen. Also, acquisition of another co-owner's co-ownership shares can take place by way of the actio communio dividendo. In other words, where the court orders that one of the co-owners takes or purchases another co-owner's shares. And we've already seen the process that's involved and that should be applied there. Acquisition of another's co-ownership shares is also possible by way of prescription. Now, prescription is a mode of acquisition of rights, and acquisition of co-ownership shares is in effect acquisition of ownership rights in property. The case of Albert and Another versus Ragavan indicated that it is possible for a co-owner to acquire another co-owner's co-ownership shares if the acquiring co-owner can prove the requirements for prescription, or if that co-owner can establish that prescription has taken place. Now, the Albert and Another versus Ragavan case was decided before the Prescription Act came into force. So if you read that case, you'll see that the requirements that were looked at there are somewhat similar to that or those requirements that set out in the Prescription Act, but there are slight differences. However, note that although Albert and Another versus Ragavan was decided before the Prescription Act, today, where the Prescription Act applies, co-owners can also still acquire other co-owners' undivided co-ownership shares if they can show that the requirements in the Prescription Act is met. This then brings us to the end of our discussions on co-ownership, even and broadly speaking also ownership.